In 1969, Prosenjat Podar was a graduate student at UC Berkeley. He became obsessed with a young woman named Tatiana Tarasoff. She rejected him, and he fell into a deep depression. He sought treatment at the University Counseling Center. During a session, he explicitly told his psychologist, Dr. Moore, that he intended to kill Tatiana when she returned from her summer vacation in Brazil. Dr. Moore took this seriously. He believed Podar was dangerous. He notified the campus police and requested that Podar be involuntarily committed. The campus police detained Podar. However, Podar was smart and calm. He convinced the police he was just angry and not a real threat. They released him with a warning to stay away from Tatiana. Podar, furious that his therapist had snitched, stopped going to therapy. 2 months later, in October, Tatiana returned. Podar went to her house, shot her with a pellet gun, and then stabbed her to death with a kitchen knife. Tatiana's parents sued the university. They argued that while the police knew, and the doctor knew, Tatiana didn't know asterisk. If she had been warned, she could have protected herself. The case reached the California Supreme Court. In 1976, they issued a landmark ruling in favor of the parents. Justice Tabriner wrote the famous line, "The protective privilege ends where the public peril begins." The court established that when a therapist determines a patient poses a serious danger of violence to others, they bear a duty to exercise reasonable care to protect the intended victim. This originally meant a duty to warn, calling the victim, but later expanded to a duty to protect, which might include hospitalization, calling police, or warning. The court decided that physical safety is more important than the sanctity of the therapy room. The mental health community panicked. The American Psychiatric Association filed amicus briefs arguing that this rule would destroy therapy. They argued that if patients knew doctors would call the cops, they would stop talking about their violent urges. If they stop talking, they can't be treated, and they become more dangerous. They also argued that predicting violence is incredibly difficult. Doctors would over-report to avoid liability, locking up innocent people just to be safe. The court acknowledged these risks, but held firm. The risk to the public was too high to ignore. Does Tarasoff apply to infectious diseases? In the 1980s and 90s, this became a huge question with HIV. If an HIV-positive patient tells his doctor he is having unprotected sex with his wife, but hasn't told her his status, does the doctor have a duty to warn the wife? She is an identifiable victim in imminent peril. Ethically, the Tarasoff logic applies. Legally, it varies. Most states have partner notification laws that allow, and sometimes require, the health department to notify partners without revealing the source patient's name. This strikes a balance, protecting the third party from harm while trying to maintain some level of privacy for the patient. The frontier of this doctrine is genetics. In the case of Peter versus Jama, a woman sued a doctor for failing to warn her that her father had a hereditary form of colon cancer. She argued that if she had known, she would have gotten screened early and avoided her own cancer. The courts are split on this genetic Tarasoff. Some argue that the genetic link makes the children patients by proxy. Others argue that the duty of confidentiality to the father prevents the doctor from calling his estranged kids. As genomic medicine advances, the definition of who is at risk expands from a single victim to an entire family tree. Today, we see Tarasoff principles codified in red flag laws or extreme risk protection orders, ERPOs. These laws allow doctors, family members, or police to petition a court to temporarily remove firearms from a person who presents a danger to themselves or others. This is a direct application of the duty to protect. It prioritizes public safety over Second Amendment rights and medical privacy. It puts the physician in the role of a gatekeeper for public violence. For a clinician, knowing when to break confidentiality is hard. Generally, 3 criteria must be met to trigger a Tarasoff duty. First, there must be a specific threat of serious bodily harm. Second, there must be an identifiable victim or group. Third, the patient must have the ability to carry it out. A vague statement like, "I hate the world," or "I feel like exploding," does not trigger the duty. It must be specific. "I am going to kill John Smith." If the threat is vague, the duty is to treat the patient, not to call the police. A common misconception is that HIPAA prevents doctors from warning victims. This is false. The HIPAA privacy rule has a specific exception for serious and imminent threats. Doctors are permitted to disclose PHI, protected health information, to law enforcement or potential victims if they believe it is necessary to prevent harm. We must not let the fear of a privacy fine stop us from saving a life. The law is designed to allow safety valves. To conclude, Lesson 4. Confidentiality is a sacred trust, but it is not a suicide pact. The Tarasoff doctrine reminds us that the physician operates within society, not outside of it. When a patient becomes a missile aimed at the public, the doctor has a duty to sound the alarm. In our final lesson of this module, we will look at the future. We will examine how AI, big data, and new concepts of adolescence are reshaping the very idea of consent and privacy. I'll see you then.